I'm the executive director here at the Quattrone Center for the Fair Administration of Justice at Penn Law. And on behalf of my colleagues and faculty here at Penn Law, Dean Ted Ruger, who will be joining us tomorrow, the Quattrone Center's affiliated faculty and advisory board, it is my honor and privilege to welcome you here, to welcome all of our fantastic speakers and moderators here to talk about technology in criminal justice reform, our third annual spring symposium. The Quattrone Center was created in the fall of 2013 to be a national leader in the prevention of errors through an innovative and data-driven interdisciplinary systems approach to criminal justice reform through research and policy activities in collaboration with criminal justice professionals. So basically what we do is, rather than looking at criminal justice in the historical legal way of case by case, we take a higher level view of the system as a system, and we examine the way different participants in the system interact with each other. We collaborate with those professionals to create and analyze data sets that will allow us to propose useful reforms to make the system work as intended and eliminate errors in criminal justice, and then further collaborate with those professionals to implement and evaluate those reforms, creating a feedback loop that will improve the criminal justice system structurally over time. Now, today's symposium is called Technology in Criminal Justice Reform, and when we talk about criminal justice reform, I think that it might be worth a minute talking about both technology and reform. And reform literally is reforming. We want to change the criminal justice system. We want to improve its quality. And so last year when we had our symposium, we talked about definitions of quality in criminal justice. And I think some of the concepts from that are going to be important here today, because really when we talk about technology and criminal justice reform, the question is, how can the technologies that we're developing today interact with the criminal justice system and professionals in ways that will improve its administration and make sure that we're managing and minimizing any unintended consequences? So, let's see if we're going to figure out how to make this work. So the graph behind me is a chart from ISO 9000, which is the global international standard for quality management. And this outlines in a single picture the features of a high-quality system in any industry. And what you see are three important components. On the left, the requirements, the specifications. What do we want the criminal justice system to do? The criminal justice system has purposes, and we would argue here at the Quattrone Center that the purposes from the commission of a crime through to the adjudication of a conviction or innocence, the purpose of that is to get the right guy in the right way. In other words, we should hold perpetrators of crime accountable for their actions. We should not hold innocent people accountable for those actions. And we should do these investigations and adjudications in ways that preserve our constitutional freedoms. The criminal justice system at writ large probably has a larger purpose. First, to define what activities we believe to be criminal, and then to manage that in the right guy, right way fashion. And finally, to design accountability mechanisms that are actually useful in reducing crime over time. And so we have the set of requirements that operate both for the system at large and for each participant in the system: law enforcement, prosecutors, defense attorneys, judges, juries, communities. On the right side, we then have the question of, is the system being accepted by the people who use it? Are the people who come into contact with the system satisfied that the system is working properly? Those of us who are interested in criminal justice reform are trying to answer this question and understand what the modified requirements are of the people using the system as they use them. That then leads to a feedback loop, which is the circle represented in the center. And historically, criminal justice has been pretty lousy with feedback loops. The feedback loops are long and delayed. Often the data doesn't exist for us to make thoughtful comments, and thus the commentary between the people providing feedback and the agencies themselves is lost in translation. And it's conversations like the ones we'll have here today that are actually the motivators and drivers of those feedback loops to create a high-functioning system where we have constant improvement from the requirements and specifications of the system to the impact of that system on the people who are using it. Ultimately, technology is simply a set of tools used to advance the purposes of the criminal justice system. And so the question is, to what extent are these technologies advancing criminal justice reform and improving the system? We're going to be talking about a wide variety of technologies over the course of the next couple of days. And all of these technologies have the opportunity to improve our ability to understand the system and to make it more complex And as any system of interlocking personnel and dynamic change, when you throw a rock into a pond, there's a ripple effect. When you make a change with technology, there are going to be impacts that stretch far and wide beyond what you're doing, and you have to be aware of unintended consequences. So for example, we'll talk about camera technology today. And camera technology, I think, has dynamically changed the interactions between citizens and professionals in the criminal justice system across a wide variety of areas. There's body cams and telephone cameras, and the civilian versus law enforcement reactions that happen there. There are surveillance cameras, which we'll be talking about, and the challenges there where you can, you have both the Boston Marathon situation where surveillance cameras dramatically accelerated our ability to identify the perpetrators, but you also have the Duke lacrosse case where surveillance cameras that were 2 miles away from where a criminal act was alleged ended up proving the innocence of people who otherwise might have been convicted of crimes they haven't committed. And then we have the operational and administrative challenges of now having all of this video data that has to be stored, identifying which parts of it should be saved, which parts of it can be discarded, and the collateral consequences of people who have nothing to do with the event and are simply going around their daily business, walking through this video and being filmed, and what does that mean for their civil liberties and privacy rights. And all of this is wrapped up in the application of technology and criminal justice reform. And what's most important is that we decide as a group, collectively, how we're going to balance these competing interests so that the system, again, is working as designed and the administration of justice can be fair and accurate. To do that is not an easy task, but I think we've made it easier by assembling a truly all-star cast of speakers who will be with us for the next couple of days. We have an interdisciplinary blend of criminal justice professionals, legal scholars, and social scientists across a wide range of disciplines. We'll hear from representatives from the police, from judges, law and social science professors, entrepreneurs, and community activists to help make sure that we're getting a 360 view of these issues. Now, we're here today, Thursday morning, and this is a 2-day symposium. And I think one way to think about that is it's a little bit like a double album. So, like Prince's Sign of the Times, album 1 is fantastic, album 2 is fantastic, but you don't really get the theme until you listen to the whole thing together. So I'm hopeful that you'll stay here both today and tomorrow. Because today, we're going to talk about risk assessment tools and predictive policing in the morning. We're going to have a lunchtime keynote from Police Commissioner Richard Ross here in Philadelphia, who's going to talk about some of the technologies he's trying to integrate into a 7,000-person police department and some of the challenges of doing that in the real world. And then in the afternoon, we'll talk about tools that allow citizens to participate more effectively and more actively in the criminal justice system and the role of video throughout the administration of justice. So that's going to be a pretty great day. Tomorrow we move into a slightly more, what I would probably shallowly describe as a more scientific day. We'll talk about statistics and people bringing statistics into the courtroom and projecting the odds of things to an audience of judges, lawyers, and juries who very rarely understand the underlying mechanisms of those predictions and therefore lack the ability to challenge and ensure the validity of those predictions. We'll talk about the Daubert rule and the challenges of expert testimony in the courtroom. Again, we'll have a lunch keynote. Tomorrow will be Chris Segoyan from the ACLU, who's done some amazing work on surveillance technologies, the role of judges in the search warrant process, and how surveillance technologies and digital technologies impact our individual civil rights. And then we'll round out the day with a conversation about some emerging forensic technologies and the challenges of evolving science in the courtroom over time, and what we do with cases that may have been decided at a time when we believe the earth is flat, now that our technology has advanced and we believe that the earth is round. So it should be 2 really exciting days, and with that, I'm going to turn it over to the team that we have here with just 1 second to go over a couple of administrative details. So number 1, we are videotaping and we are audio recording, so we hope that each of you will be at different times participating in the dialogue and asking questions. When we get to the Q&A period, we will direct you to the 2 microphones that are here on either side of the room. And we just ask that you identify yourself and speak into the microphone so that we can record the question and keep that going for future video presentations. Should you be wanting to use the wireless network, there's information in the packet that you got when you checked in. If you would like to be Facebooking or Instagramming or using the apps or tweeting about the conference, we ask that you use the hashtag QC Symposium. You should also follow us on @Quattrone Center, which is the most thoughtful daily feed about comments on the criminal justice system, I think, in the United States. Thank you. Why are you laughing? So with that, again, I want to welcome you here. In particular, I want to introduce Sandy Mason, one of the inaugural class of Quattrone Center Research Fellows, who will moderate our first panel on risk assessment tools. We couldn't be happier to have Sandy. She's a criminal and constitutional law expert with a focus on risk prediction and preventive restraint, so she's absolutely a perfect person to moderate this panel. She comes to us having spent several years at the Orleans Public Defenders. She was a Furman Fellow at New York University School of Law. She has 2 federal clerkships, one at the federal district level with Judge Phil Restrepo, who has since been promoted to the Third Circuit, and one with Judge Sloviter when she was on the Third Circuit. She has a BA summa cum laude from Yale before kind of stumbling a bit and only getting her JD at NYU Law magna cum laude. What can you do? So with that, Sandy, take it away.
Unexpectedly lengthy introduction. Good morning, everyone. Thank you for being here first thing in the morning. It's a good thing you are, because we have a fantastic panel to kick off this symposium. This panel, for those of you who know the reference, is the Minority Report panel. It is about how the criminal justice system predicts who is likely to commit future crime. Specifically, we'll be talking about new technologies of prediction or forecasting. I'll use both those terms, the opportunities they present, and the fascinating legal and moral questions they raise. Now, there are actually, as John said, 2 panels on prediction this morning. Predictive policing is up next. So the scope of this panel is on prediction or risk assessment after arrest. When does risk assessment happen in the course of a criminal case? It happens at many points along the way. Risk assessment informs pretrial custody determinations, charging decisions, plea negotiations, sentencing decisions, probation tactics, prison security classification, and parole decisions at the back end. Now, that's been true for a long time. But the reason we have a panel on risk assessment in this symposium is that our methods of risk assessment are undergoing a fundamental shift. The criminal justice system is turning to actuarial risk assessment. Now, that is not entirely new. Parole boards have been using actuarial instruments since the 1930s. But 2 things are new. The first is the fact that so many actors in the criminal system are deploying actuarial risk assessment at so many stages in the process. So 2 major examples are the ongoing pretrial reform movement, which aspires to deploy actuarial risk assessment at the pretrial stage, and the evidence-based sentencing movement, which deploys actuarial risk assessment for purposes of sentencing. The second thing that is new is that our methods of risk assessment are rapidly improving. So there are 2 basic methods of risk assessment that the criminal justice system deploys. The first is the use of what's called a checklist instrument. The second is the use of a machine learning procedure, machine learned algorithm. We are getting much better at both. Our access to big data is making us much better at both. And our new prediction abilities present opportunities and challenges we've never faced before. Now, before we move on to our substantive discussion of those opportunities and challenges, I want to clarify the 3 kinds of questions or objections we might raise about actuarial risk assessment. If I have an objection to actuarial risk assessment in the criminal process, it might be an objection to 3 things. I might be objecting to, number 1, the fact that we have decided to engage in prediction in the first place. Number 2, the methodology of prediction, or some aspect of the methodology. Or number 3, the response to the prediction. So as we have this conversation, I want us to be thinking throughout, if we're talking about some issue, are we talking about a concern with the fact of prediction, the methodology of prediction, or the state's response to a given set of predictions? The format of this panel is going to be 3 short presentations by our panelists, followed by some moderated discussion, and then audience Q&A at the end, so think of good questions. And now I'd like to introduce our fantastic panelists. We have, at far right, Richard Burke, Professor of Criminology and Statistics here at the University of Pennsylvania. Richard's work in applied statistics transcends the conceptual and technical expertise of most people at this university. So it is fascinating and impressive work. Richard has spearheaded the development of machine learning procedures for forecasting in criminal justice, and he will educate us about the technical mechanics of different methods of forecasting. At center is Ezekiel Edwards, the director of the ACLU's National Criminal Law Reform Project. Excuse me. As director of the Criminal Law Reform Project, Zeke has pursued an ambitious agenda of strategic litigation and policy advocacy aimed at ending mass incarceration and promoting racial justice, among other things. So Zeke will present an expert perspective on the implications of actuarial risk assessment technologies for racial justice and civil liberties. And then at far left is Sonia Starr, professor at University of Michigan Law School. Sonia has accomplished the rare feat of combining deep expertise in legal doctrine and theory with deep expertise in quantitative methods, and has become one of the most prominent critics of actuarial risk assessment in the criminal justice process, particularly in sentencing. Her article in the 2014 Stanford Law Review, Evidence-Based Sentencing and the Scientific Rationalization of Discrimination, mounts a set of powerful constitutional critiques that she'll be expanding on here today. So with that, I will turn it over to Richard to start.
Okay, I have 15 minutes to cover material that I normally cover in 14 weeks. So Sonia suggested I have to talk very fast. I can't really do that, but I'll try to give you an overview. So this is my 15 minutes maybe of fame, or maybe of infamy, depending on how well I pull this off. Fortunately, Sandy's already raised some points that I was going to cover in the first couple of minutes. And the first point, just to summarize, is this is old hat. Forecasting has been going on, risk prediction has been going on since the 1920s in parole, and is now very widespread. It has, however, become increasingly actuarial and increasingly statistical, because those particular perspectives do better than judgmental decisions. On the other hand, judgmental decisions are really actuarial too. A judge sees an offender standing before him or her and says, oh, I've seen people like you before. You're a troublemaker, off you go to prison. Or you're a good risk, I think you're going to do well, off you go to probation.
So the idea of doing risk assessments based on the collective experiences of individuals like the person who's being considered is not new. We're just doing it in a more technically powerful way than in the past. Another very important point of background is that these decisions are made by a particular individual, and the forecasts are meant to inform those decisions, not determine those decisions. This isn't lock and key. This is just another form of information, a more precise form of information than has been used in the past, but it is not definitive. And finally, and this comes up all the time, when you talk about these techniques, all kinds of objections can be raised based on the yardstick of perfection. Yup, these things aren't perfect. We make forecasting errors, for sure. The yardstick is current practice. The yardstick is whether we can do better than judges do now, or magistrates do now, or parole boards do now, or prison officials do now. We have to do better, we don't have to do perfect. And that's an important point of confusion that often comes up in the evaluation of these tools. Okay, here's machine learning in a picture. So I have this wild animal preserve. I have 2 endangered species, lion and buffalo, and I got to figure out a way of putting a fence between them so they don't kill each other. I don't know on scientific grounds where these individuals are. I don't have a theory of ecosystems which tells me exactly where to find the buffalo and exactly where to find the lions. There's no theory. So what do? I walk the terrain very carefully, no doubt, or I fly over the terrain and I look to see where these creatures are. And depending upon where I locate them, let's say in GPS metrics, I build a fence. That fence is located by longitude and latitude. There's nothing about, for example, the availability of water or the availability of tree cover or other prey or other creatures that might be serving as food. It's strictly done empirically. Now, once I have this fence, I hope I've done a pretty good job separating the two species. In the future, someone comes to me and says, where will I find the lions? I say, well, just look at the fence and go to the left. I don't know why they're there, but I'll tell you, you'll find lions there and you won't find buffalo. Or they say, where will I find the buffalo? I say, look at the fence, go to the right. That's where you'll find the buffalo. I don't know why they're there, but I guarantee you'll find buffalo there and you won't find lions. That's basically machine learning. We have algorithms that work with enormous amounts of data to put boundaries between different kinds of offenders. Those boundaries are not necessarily based on models or theory or subject matter knowledge, although those things can help for sure. Those models are based on a brute force effort to search through the data to find associations that work in the sense that they are highly accurate. And then in the future, once we have this information in hand, we can use that format for forecasting, and we forecast very, very well. That's basically what machine learning does. Of course, there are 15 weeks, 14 weeks of details on how the algorithms do that, but that's all they're really doing. These are just sophisticated search techniques, not informed by subject matter theory, but informed by the power of algorithms to find associations in the data. That's the whole game. This is another way of representing the process. We have some inputs. In the case of our nature preserve, longitude, latitude, maybe altitude. We have those as W, X, and Z. Those are just predictors in the usual sense we take that term. The computer takes those, pulls them apart, rearranges them, transforms them into formats that allow for strong associations with the outcome. In machine learning, we allow for at least two kinds of outcomes, numeric, which we call Y, and groups or categorical that we call G. Either work. There's a black box here because the algorithm doesn't tell us at the end exactly how these predictors are used. So machine learning cannot be confused with a model. We have no explanatory power. We know which variables are associated with which predictions. So for example, in criminal justice circumstances, we know that the age at which a person commits their first crime for which they're charged an adult is a powerful predictor. We don't know why. I mean, we can all speculate about why. But there's nothing in the machine learning algorithm which gives you the mechanism. It just says, if you know that fact, you're going to predict with substantially greater accuracy than if you don't know that fact. So it is a black box. And that is a concern that has been visible for a decade or more. We're working on it. We now have the ability to peek a little into the black box, but it's still essentially a black box algorithm. A problem that comes up in any kind of forecasting circumstances, I was talking to a few of my colleagues before the session today, is an acknowledgement that we're not only going to make forecasting errors, but not all errors are created equal. What machine learning allows one to do is to differentially weight the costs of different kinds of forecasting errors. So I have archetypes here. The judge is looking at a convicted offender and wondering, do I have before me a Darth Vader or do I have a Luke Skywalker? Tough question. Clearly, I don't want to release the Darth Vaders, and they're going to destroy, the person will destroy several planets. On the other hand, I don't want to incarcerate Luke Skywalker because, after all, Luke Skywalker will defeat the Empire. Tough call for a judge. The judge has to make that call, however, and anticipate that the consequences of the mistakes, releasing Darth Vader, incarcerating Luke Skywalker, the consequences of those mistakes are different. And the relative costs are different as well. So it's very important that when the decision is made about what to do for this individual, that the differential costs of those mistakes get integrated into the forecasting procedure. That allows the forecasts to differ in contrast to when we treat those costs as the same. That in turn makes the forecast different. A person might be classified differently depending upon the relative cost of those two kinds of mistakes. It's a key feature of machine learning. It is not a key feature of conventional modeling, and in fact, a weakness of those models. And if you talk to anybody who uses this information, they'll readily agree, oh yeah, all mistakes are not created equal. I must have those somehow integrated into the forecast you give me. Machine learning actually does that quite effectively. Now, issues that come up in this. First issue that comes up, are we doing better than conventional practice with respect to accuracy? The answer to that is pretty clear, and it's yes. Mathematically, you can show it. Simulations, you can show it. Experience, you can show it. On the average, you do no worse than conventional methods. Typically, you do better, often much better. Transparency, well, that's partly in the eye of the beholder. Anybody who wants to look at the code that is used in these algorithms can have at it, and it's absolutely transparent what the code is doing. There's no mystery. No one's hiding the ball. Practicality, that's tougher. Typically, to implement these procedures, you have to be working in jurisdictions where the IT technology is pretty good. So it works pretty well in places like Philadelphia or Boston or Chicago or Los Angeles. It might not work so well in rural counties where the IT technology is not there, and the access to databases that you need is not readily available. And finally, fairness. That's a tough one too, but again, it's compared to what? No one is claiming that these algorithms are completely fair. I don't even know what that could mean, although there's actually some interesting statistical work on what that could mean. The point is whether it's more fair. Now, there are many dimensions to fairness as well. I'm sure we'll hear more about that throughout the discussion this morning. But the yardstick is, again, current practice. What judges currently do, what parole boards currently do, what probation officers currently do, what prisons currently do. Can we be more fair than that? And I think the answer is yes, but you may hear different opinions in the next 45 minutes or so. I'm done. Can I just pull this, pull this, pull this?
Now, while Sonia's getting set up, can I ask you, Richard, in 2 or 3 minutes, could you just tell the audience a bit about your domestic violence forecasting pilot in Philadelphia?
Sure. We're working with a group in Philadelphia here that's engaged in reforming pretrial process. We just got a large grant from MacArthur, and the city is throwing in money as well. Among the problems that needs to be addressed is what happens at preliminary arraignments in domestic violence cases. Those cases often tend to involve serial crimes with the same offender and same victim, and those crimes can be pretty horrendous. So the idea is to provide information to help magistrates assess the risk of reoffense. Of course, we're also worried about FTAs, whether people fail to appear. But the immediate pressing problem is, do we dare release a given person or not, based on the possibility or the prospect, based on forecasting, they're going to commit a serious crime. So we worked using machine learning tools with a database of about 30,000 cases, and we're able to show that if you were to use, if the magistrates were to take seriously our forecasts, you'd cut the rearrest rate for domestic violence in Philadelphia in half. So it's a pretty substantial effect. We're now moving on to other applications, for example, for drug offenders and other special types of offenses, with the same goal, not to determine the outcome, but to allow magistrates to be better informed when they make those decisions. You all know those decisions are made in a matter of minutes, with very little information about the individual or the crime. There are seat-of-the-pants forecasts being made on the fly. Not surprisingly, we can do better than that.
Great, thank you so much.
Okay, thank you, Sandy, and thank you to all of the organizers of the symposium. So I'm going to focus on the question of what variables go into the risk assessment instruments and whether reliance on those variables is constitutional. I'm not going to focus on machine learning methods. The examples I'll give will have to do with what Sandy called checklist instruments, which are basically, they're based on past regression studies of prior offenders, and regression coefficients are sort of loosely translated into numbers of points on a risk that go into a risk score. So a judge in, say, a pre-sentence investigation report or something is presented with a probability of reoffense based on extrapolation from prior offenders. In any case, my view is that if the variables you are relying on are unconstitutional and inappropriate, they will remain so whether you're loading them into a regression-based instrument or a machine learning algorithm or whatever. Sandy mentioned most of this has been set forth in more detail in the law review article. If you want a much shorter version, you can look at the Federal Sentencing Reporter. My written work has focused on sentencing. That's also what I'm going to give examples on today, but basically the same arguments apply to parole, which is a much older usage, and really to a lot of other uses in the criminal justice system, such as in bail. I am mostly going to focus on equal protection concerns. I want to briefly mention a couple other constitutional objections one might have to these instruments. First, there are procedural due process concerns related to the lack of transparency. So it may be true, for instance, that the instruments that Richard has been working on, the code is available to anyone, but the instruments, the checklist instruments that are vastly more commonly in use already in the criminal justice system today. The most common ones are proprietary corporate instruments in which the weights, that is the number of points associated with particular variables, is actually not made available to defendants, and I think that that is a concern. There's also an issue of, potentially an issue of self-incrimination, because defendants are being told that participation in risk assessment interviews is effectively mandatory. But I mainly want to focus on a substantive question of is it okay to sentence people based on who they are and their socioeconomic backgrounds, in addition to their criminal conduct? What variables are in the instruments? Well, different instruments vary, but there are some commonalities. So, surprisingly, almost none contain really any details at all about the actual crime for which the defendant is being sentenced. All of the instruments do include several variables related to prior criminal history. Most also contain gender, age, employment status, education level, and marital status. The most popular instruments, like the LSIR and Compass, include a whole battery of more detailed background factors, such as financial problems, past or present trouble paying bills, reliance on social assistance, whether parents or other family members have a criminal record or have been to prison. Compass asks whether your parents used drugs, whether the defendant or any of his family members has been a crime victim, whether the defendant lives in a high crime neighborhood, quality and stability of accommodations, failure to participate in organized leisure activities like clubs. Look, on policy grounds alone, I think we should be concerned about this. Essentially, if you wanted to come up with a list of every possible indicator of socioeconomic disadvantage you could think of, that's pretty much what say, LSIR and Compass have done, and all of those are risk-heightening factors, right? I think it is certainly bad policy for the state to direct judges to deem classes of people more dangerous and sentence them for longer or let them out of prison on parole later on the basis of their poverty and their demographic characteristics. Beyond being bad policy, though, a harder question is whether it's unconstitutional. So I'm not going to make the claim that actuarial sentencing per se is unconstitutional. Again, I'm focused on particular variables. The ones that I think there are really viable constitutional arguments against are gender and the socioeconomic variables. There may possibly be viable arguments against family, against certain other family-related variables. First, gender. This, I think, will be maybe less controversial, but I think it provides an important background for the rest. So, you all are familiar with the law here. The state bears the burden of establishing an exceedingly persuasive justification for gender classifications. This is a tough test to satisfy. So, in addition to the requirement that the state prove a strong relationship to important government interests, the Supreme Court has also constrained the types of claims that can be made to establish that type of relationship. So the state is not permitted to defend gender discrimination on the basis of generalizations about what, on average, men and women tend to do. And that's true even if those classifications are empirically well supported. So I refer to this as the prohibition on statistical discrimination. Statistical discrimination is a concept from economics. So some economists argue that that discrimination can be rational when the characteristic in question is being used as a proxy for valid interests, like say crime prevention, and a statistically accurate one. But the Supreme Court has roundly and repeatedly rejected this distinction between statistical and other forms of discrimination, at least where race and gender are concerned. So on gender, for instance, in Craig v. Boren, the court struck down a drinking age law that discriminated against men, even in the face of a raft of studies showing that young men posed more than 10 times the drunk driving risk of young women. In JEB v. Alabama, the court said the prosecution can't rely on gender when striking jurors, even if there are plenty of strong empirical studies showing a difference in the way jurors vote. There's lots of other examples. I won't go through them all now. In all those cases, though, the court conceded the point that the statistical claim was probably accurate, right? And in at least some of them, the state's interest was important, preventing drunk driving deaths, for instance. So why does the court reject these arguments? Well, the answer goes, I think, to the core of the Supreme Court's equal protection jurisprudence, which, for better or sometimes for worse, is highly individualistic. The core idea is that individuals have a right to be treated as individuals, not lumped in with others that share their characteristics. So not every person fits the average of their gender. So until the emergence recently of actuarial risk assessment, it was in fact vanishingly rare for the courts to explicitly account for gender in sentencing, at least in the last 60 or 70 years. Judges just don't say in open court, like, well, one co-defendant, these two co-defendants did the same thing, but she's a woman and he's a man, and everyone knows men are more dangerous, so I'm sentencing him to prison for 10 years longer. On the few occasions when that has happened, courts have been summarily reversed. And yet, actuarial risk assessments do exactly the same thing. They just mask it by putting it in the form of a risk score. So I think the prohibition on statistical discrimination really destroys any attempt to defend gender-based risk assessment because all of the justifications for it are grounded in reliance on statistical generalizations. And crucially, that same principle is also the reason that it's unconstitutional to discriminate in sentencing or parole based on socioeconomic factors. So lawyers and legal scholars have widely overlooked this problem, and I think that's because in other contexts we're used to thinking of socioeconomic discrimination as a losing constitutional argument. And it's true, in other contexts, it is usually a losing argument. The criminal justice system, though, is different. So for more than half a century, the Supreme Court has had doctrine that applies an especially demanding standard of scrutiny that blends equal protection and due process concerns. It's not identical to existing tiers or to other tiers of equal protection scrutiny. But it applies it to cases affecting indigent criminal defendants. So the seminal case is Griffin v. Illinois, which described the provision of equal justice for poor and rich as the central aim of our entire criminal justice, or rather our entire judicial system. And the court says, in criminal trials, a state can no more discriminate on account of poverty than on account of religion, race, or color, which is a strong statement because all of those other classifications get strict scrutiny, right? So in 1983, in Bearden v. Georgia, the Supreme Court applied this principle for the first time in the sentencing context. So it arose from a probation revocation hearing, right? So Bearden had been sentenced to probation, he lost his job, and the state wanted to get his probation revoked. The court unanimously held that this would be unconstitutional wealth discrimination. I'm going to skip the standard of review here. It's basically a form of heightened scrutiny, and it requires an assessment of alternatives as well, which is sort of a hallmark of strict-ish scrutiny. The state made a couple of arguments. I'm going to focus on the second argument. So the state said the defendant's unemployment increased his crime risk, and it introduced a bunch of empirical studies showing a link between unemployment and poverty and recidivism. The court roundly rejected this argument. It said its reasoning was really the same as its response to the statistical discrimination justifications in the gender context. The court says the state cannot justify incarcerating him solely by lumping him together with other poor persons and thereby classifying him as dangerous. This would be little more than punishing a person for his poverty. And I think that is exactly the problem with actuarial sentencing. The actuarial instruments lump defendants together with other people who share their socioeconomic characteristics and thereby classify them as dangerous. They punish people for their poverty. The Supreme Court has already unanimously held that this is unconstitutional. The case is still good law. It just seems like a lot of people have forgotten about it. I think that Bearden really directly invalidates reliance on socioeconomic variables for sentencing risk assessments. And so part of my sort of legal crusade has just been sort of like, hey, look over here, there's a constitutional case you can use. I've been trying to do like trainings and get defense counsel to know about it. I do think that most of the other variables in the instruments are probably constitutionally permissible. Obviously, race wouldn't be, but race actually isn't in any of the actively used instruments. Zeke will talk about the racially disparate impacts that it has, which I think is a concern for policy reasons, but under existing doctrine, not a basis for a constitutional argument. Other classifications like age and marital status, for instance, are routine bases for differential government treatment. I think that there is actually a potentially strong argument against the use of family background factors, such as whether parents or other family members have been to prison, or whether one grew up in a stable household. Parental incarceration, for instance, I think is very hard to distinguish from illegitimacy, which is a characteristic that gets heightened scrutiny. It's a highly stigmatized, disadvantageous trait over which the defendant has no control. That said, that would be a novel constitutional argument, whereas the rest of the argument I'm outlining here is sort of like established constitutional doctrine and therefore easier, I think. Okay, so some risk assessment advocates have addressed really just the gender concern, and they've addressed it fairly dismissively, saying, well, gender discrimination might be subject to intermediate scrutiny, but it survives it because women really do commit fewer crimes, and taking that into account then serves the important state interest in crime prevention. I'm unconvinced by this for a few reasons. The first is the point we've already made, that is, the argument that women really do commit fewer crimes is exactly the kind of statistical generalization that the court has repeatedly prevented the state from relying on in formulating arguments for why important state interests are satisfied. That's not superseded by a claim that the interest is important. It's a limit on the type of argument you can use to show the relationship to a government interest. Let's ignore that for a minute. So if the state were allowed to rely on statistical generalizations, could it satisfy its burden to defend the use of these contested variables? I still say no, at least not with the empirical evidence that's currently available. And keep in mind that it's a state that bears a heavy burden of proof. I'm going to concede for the moment the point that actuarial risk assessments at least are capable of outperforming judges' individualized analyses of risk. I don't think all of the ones that are in use actually do, but I believe that the types of like fancy instruments or algorithms that Richard is developing probably do. That isn't really the question, right? In an equal protection case, what's at issue is a particular classification. And so the legal question is whether if we concede that we can make these generalizations at all, right? Then the question would be, does the addition of these variables serve an interest beyond like an instrument that didn't have them or that had other things instead. And I don't think the state can meet that burden. So the thing is that factors like gender and socioeconomics are correlated with crime. But once you already have, say, 2 defendants who have been convicted of the same crime already, and you're already accounting for past criminal conduct, there's several studies that show that adding these problematic variables it doesn't actually add very much marginal predictive value. I mean, of course, any variable you add is going to get you something, right? But getting another percentage point or 2 of accuracy to a model, I think, is not the kind of marginal gain that is sufficient to overcome a heightened level of constitutional scrutiny. Also, the Bearden analysis, at least for socioeconomic status, requires that alternatives be considered. And so, for instance, you might have to compare the existing instruments to an obvious alternative of an instrument that includes some characteristics of the thing that the defendant is being sentenced for, which is something that current instruments don't include. Would that be more accurate? I don't know, but it's the state's burden to show that it isn't. I skipped a number here. So finally, if the purpose of risk assessment is to protect the public from the defendant's future crimes, I want to argue that the risk assessment instruments are not actually asking the right question. So these instruments are meant to predict recidivism risk in the abstract. They ask, how risky is this person? What they don't ask is, how will the judge's sentencing decision or bail decision or parole decision affect that risk? And that's really the question for the purpose of protecting the public. And the thing is that almost everyone you put in jail or prison is going to eventually get out. And so just the fact that you decide, oh, we're going to send them to prison for 3 years versus 1 year, like, it's not obvious that that net protects the public more. The people who have the highest recidivism risk are not necessarily the people whose recidivism risk is going to be the most reduced by incarceration. In fact, it is perfectly possible that people who are more crime prone to begin with may actually be more likely to be hardened rather than helped by prison. We really don't have the science in place to know what subsets of people will have their behavior change the most by prison. It's actually a much harder task than the purely predictive tasks that today's risk assessment instruments engage in. It's a task that involves causal inference that's very complicated. And so we're just not there on the empirics. Okay, I know I'm just about out of time. I want to very, very briefly, I'll skip this point, I bet that is one factor among many. I want to very briefly address the question of like, okay, but what about the comparison to what's happening now? Because maybe judges, they already consider risk, maybe they're probably at least implicitly already considering all these problematic factors already. So just a few points on that. One is that, of course, judges...
Sonia, I'm sorry to cut you off. Can we save this for the discussion?
Yes.
Okay. We will come back to that very pressing, important question. Thank you so much.
Good morning. First, just preliminarily, it's good to be back at Penn Law, from where I amazingly graduated 14 years ago. It's also always humbling not only to be on a panel with people who are far brainier than I am, but also with former classmates like Andrew Ferguson, whose outlines I relied on to graduate from Penn Law, and professors like David Rudofsky, for whose class I did not perform as well as I wish I had. It's also a little bit ironic that I'm on a panel or in a conference that has the word statistics and technology, but with that ringing endorsement. I want to talk a little bit, I'm going to talk in the pre-trial context about risk assessments, and I wanted to say also preliminarily that the ACLU at this point nationally does not have what I would call a firm position yet on the use of pretrial risk assessment tools. We have some concerns which I want to highlight, but I'd say the jury is still out. One of the reasons that we are open to these, however, to some extent, is that I don't think the jury is still out on the fact, as has been referred to a little bit, and we were going to talk about, I think Sonia's going to talk about for a second, is that we don't think the status quo is working when it comes to pretrial detention and why and how people are detained. As many of you probably know, we have about 750,000 people who are in jail on any given day in this country, about 70% of whom are unconvicted. That population alone, I think, would give us something like the third largest prison population in the world. Many of those people are there simply because they are too poor to post bail. And so we incarcerate way too many people pre-trial than we should. So whatever it is that we have been doing over the last 10, 20, 30 years isn't working, and we should change it. So the idea of bringing in some sort of potentially evidence-based, more objective risk assessment to those decisions would be welcome if they work. I'd also note that we have affiliates, like our New Jersey affiliate, who are endorsing reform to pretrial determinations and are currently, following the passage of legislation in New Jersey, creating risk assessment tools that they think will significantly lower the pretrial jail population and allow many people out who shouldn't be in and only hold people in who should be there. The jury is overall still out on that. The reason that we have concerns, and by the way, I apologize, because I'm a technophobe, I'm also not using a PowerPoint. The reason we have concerns is in part, and folks here can talk more about this than I can, but data is inherently subjective. And when it comes to pretrial, really a lot of these risk assessment tools, and certainly pretrial tools, it seems all of them include criminal history, past criminal convictions, sometimes arrests, in terms of trying to determine who's going to commit future crime. And that data is inherently subjective because it is based on discretionary decisions that our criminal justice system makes every day, and those are infused with bias. These are decisions mostly by police departments, about where to deploy their resources, whom to stop, whom to arrest, whom to charge, and certainly by prosecutors, again, whom to charge for what, whom to seek bail and pretrial detention about. And so you are dealing with a data set that seems quite contaminated. It's also true when it comes to crime that we really don't understand or know the universe of crime that is committed. There's a great deal of crime that is unreported, far more than you may imagine. And so you are also dealing with an incomplete data set. And so you are making predictive decisions that are not only infused with bias, but also from a data set that really you don't know the full extent of. In terms of abuse of discretion, I'm just going to talk a little bit. Sorry, being tall is good in some ways. I want to talk, this audience will probably know a bit about this, but in terms of the abuse of discretion, the ACLU has spent a lot of time looking at the ways in which police particularly make decisions based on race. I think you know that there has been a lot of litigation and exposure of stop and frisk around the country, particularly in New York, where 4.4 million people had been stopped over an 8-year period, 83% of whom were black or Hispanic. Most of those, 90%, did not result in any further law enforcement action. Only 10% of those stops were of white people. Here in Philadelphia, we saw similar patterns. Both those cases led to litigation challenging stop and frisk practices. Professor Radowski is lead counsel on one of those cases. We have seen similar patterns in Illinois, where our affiliate documented widespread racial disparities in who is stopped. in Boston, in Miami Gardens, and the DOJ's report in Ferguson. All across the country, you are much more likely to be stopped and searched if you are a person of color. We've also documented such disparities when it comes to arrests. We put out a report on marijuana arrests a few years ago, a national report documenting that over a 10-year period from 2001 to 2010, blacks were over 4 times as likely to be arrested for marijuana possession than whites, notwithstanding comparable usage rates. We found that in some states it was 6 to 8 times as likely, some counties 15 to 20 times as likely. We put out a report recently in Minneapolis showing that blacks were 8 times more likely to be arrested for vagrancy, 9 times more likely for disorderly conduct, 12 times more likely for marijuana, and 17 times more likely for curfew and loitering violations. We documented this in cities throughout New Jersey. We just put out a report in Tampa showing that blacks were twice as likely to be summoned for seatbelt violations. And so we know that when it comes to what kind of data you're relying on in terms of past criminal conduct, what you're really measuring is past police behavior more than you are who and where crime is being committed. I have a couple examples. I was a public defender in the South Bronx for a while, and I'll just give you 2 examples. I had a 17-year-old kid who used his Metro card, which is a school Metro card, on Election Day. And for that, he was arrested, spent 24 hours in jail. That is not something that would happen to a white kid in New York. I had a 47-year-old woman who switched subway cars while the train was in motion, which wasn't a crime when I was a kid in New York, but apparently was later on, because a man was making her uncomfortable. She was arrested and spent 24 hours in jail for that. That kind of criminalization and targeting happens all around this country and would seem to significantly distort crime data that we're relying on to make predictive decisions about who's going to commit crime. I also wanted to make the point that this is something that has been woven and done throughout history. I read a book a couple years ago called Slavery by Another Name by Douglas Blackman about the re-enslavement of black Americans after the Civil War. And he starts that off with a story about a guy named Green Cottingham in Alabama who was arrested for vagrancy. And he talks about how vagrancy was a crime that was really concocted from legal obscurity, and then it's the crime of not having a job. And when, at a time when there was massive unemployment throughout the South among whites and blacks, it was used exclusively to criminalize unemployed black men. And so Green Cottingham's offense really was blackness. And that was in 1908. And we see a lot of that today when you look at the data. So again, our concern is that risk assessment models are fundamentally biased, not because of who's necessarily committing the crime or who's at risk of committing crime, but who's at risk of getting caught, and fundamentally biased because of the structure of policing and of our criminal justice system, which is inherently biased. There's also a lack of representation because of this myopic focus on race when it comes to criminal activity. In the first few pages of his book, The Condemnation of Blackness by Khalil Gibran Muhammad, he says, in all manner of conversations about race, from debates about parenting to education to urban life, black crime statistics are ubiquitous. By the same token, white crime statistics are virtually invisible, except when used to dramatize the excessive criminality of African Americans. Although the statistical language of black criminality often means different things to different people, it is the glue that binds race to crime as it has in the past. And so while I think, Sonia mentioned that race isn't actually put in risk assessment tools, that's not a factor that is ostensibly considered, it seems like it is dripping with race when it is involved, when you're looking at things like not only some of the socioeconomic issues, but also when you're looking at criminal records. And so in a sense, it seems like race very much is part of the variables, and that needs to be discussed. And so our fear is that we're going to use statistics and data that is contaminated to further sanitize racial injustice and justify continued disparate treatment. Got a little more time? I then wanted to just flag, and these are maybe things we can talk about more, which is less, I guess, a data concern than it is an administration concern. Some things with risk assessment tools that we're very concerned about. One is while we definitely want to lower the pretrial jail population, again, that doesn't need to be there. We are concerned that we're going to move into a regime of what I would call non-incarceration restraint on liberty, the over-supervision of people who don't need to be supervised. And there have been studies that show that when lower risk defendants get out, according to risk assessment models, they're often over-supervised, and it's more likely that they're going to then fail and end up back in jail because of that over-supervision. And so if we just succeed in moving people from jail to this kind of over-supervised restraint of liberty world, often defined by race and class, I don't think that's a significant enough victory. A couple other things that we're concerned about. One is the use of, if you're going to have risk assessment tools and you're going to release more people, hopefully, you do need to have robust pretrial services, which a lot of places do not have. Something that often steps in place of those are private probation companies, which we see in the post-conviction context, but we also see in the pretrial services. Private probation companies charge people for those probation services, saddle them with debt. They often then end up failing to pay and back up in prison. And so that is another concern we have. I'm also concerned that when you have risk assessment tools, it often allows for the alternative to allowing somebody out is preventative detention. And even though we have a form of that today with the abuse of money bail, if somebody scores, let's say, 2 on a scale of 2 or 3 on a scale of 10 for risk of future violent crime, or 4 or 5 on a scale of 10 for risk of future crime generally, even if that actual risk is fairly small as a percentage, is that going to result in more preventative detention than we currently have today? A couple other quick things is, if you're going to have risk assessment tools, and this is true for bail generally, pretrial generally, you want and need lawyers there to argue, what does this score really mean? And what is not included in this score? What can I tell you about my client that you can't just tell from a number? And throughout the country, to my shock, really, when I started doing pretrial justice work at the ACLU, lawyers are absent in a lot of courts, pretrial courts. They're not present at a lot of bail hearings. They're not there to make appeal bail decisions. And so another fear is that you're going to have judges using risk assessment tools without the input of advocates. The last thing, two other quick things. One is we're concerned with how these risk assessment tools are going to be used in terms of the determinations by judges and prosecutors beyond the pretrial release decision. So there's sentencing, but what about in future cases? What about other agencies? If they get, how private will these be, and how can this information be used to continue to discriminate people in other contexts if they're deemed high risk for future criminality? And the last thing is, I'm always concerned that we're not including the communities most directly affected in this discussion. What is their feeling about risk assessment tools? James Baldwin said in 1972, if one really wishes to know how justice is administered in this country, you don't question the policemen and the lawyers, the judges, and the protected middle class. You go to the unprotected, those who need the protection most, and listen to their testimony. And I feel like that is not something that is happening when we're talking about assessing individuals and communities for their risk of criminality. Thanks.
All right, thank you so much to all 3 panelists for those presentations. We'll have a brief discussion and then open it up to you all. So to begin, let's return to Sonia. Now we've heard that there is concern with a number of potential risk factors, socioeconomic factors, gender factors, Sonia says are bad policy and unconstitutional. Criminal history factors may not be unconstitutional, but they import the past bias of policing and law enforcement practices. So the question is, isn't this better than what we're doing anyway? If we're not using actuarial risk assessment, aren't judges doing the exact same thing but without accountability and transparency?
So I want to first sort of contest the question that, or the premise that all all we should be looking at as whether these instruments outperform the status quo. Like, we've got a pretty bad status quo in a lot of aspects of our criminal justice system, like, no doubt about that. We also have a political moment in which people are, from across the partisan spectrum, are for the first time in decades actually looking seriously at criminal justice reform at a lot of different stages. And I worry about the fact that this movement has seized on risk assessment as the tool to append to, like, just about every criminal justice reform. Like, oh, you can have this diversion from incarceration program, but only if you pass the risk assessment, right? We have this momentum, like, we can focus on actually doing things that try to fix the problems in the existing system without committing ourselves to a system that I believe is not only implicitly, but explicitly discriminatory. I'm sure that it's true, it's like part of what I study in the rest of my work, that judges and other criminal justice system actors in some cases engage in inappropriate discrimination. I think that's something we should see as a problem rather than something that we should codify by actually explicitly putting it into a system that we tell judges to use. I also think that as an empirical question, while it's true, for example, at sentencing, it's certainly true that a defendant's poverty may be a factor that judges take into account implicitly when assessing risk. It's not, however, entirely obvious which direction those factors cut on balance, because many of the factors associated with socioeconomic disadvantage that these instruments treat as risk factors are also the types of things that defense counsel have traditionally introduced as mitigating factors in sentencing. Because they mitigate culpability, right? And judges at sentencing especially, maybe more so than decision makers at other stages of the process, are in the business of of weighing a lot of factors that are different in kind, right? Both risk reduction and general deterrence and also retributive justice and a sort of broad variety of concerns. I think there is reason to believe that the provision of quantitative risk assessments will put a thumb on the scale in favor of emphasizing risk at the expense of those other factors. And it's not that I don't think risk, by the way, is a relevant factor to consider. I'm not like making a brief for purely retributive sentencing or something. But I'm just saying that I think that when you quantify things, there's lots of evidence in other contexts that humans in general like to defer to numbers and expert reports, and especially when it sort of takes the weight off of a cognitively demanding and emotionally demanding process like sentencing. I did a little experiment just with my students, like 85 students. I split them in half. I gave them each a detailed fact pattern about 2 defendants. And in the defendant, they all had the same facts, including all the same risk factors. And what I did is I made they're basically the same crime, but I made one defendant a little bit riskier than the other, and one defendant a little bit more culpable than the other, if that makes sense, a little more morally culpable. And the only thing I changed was at the end of this page-long fact pattern, I added a sentence where I gave half of the class a risk score. And what happened was, in the version without the risk score, most of my students gave a lesser sentence, or at least among the ones that didn't give them the same sentence, the vast majority gave the lesser sentence to the riskier defendant and the greater sentence to the more culpable defendant, right? That pattern dramatically reversed, and a clear 2/3 of the students in the class, or 60% of the students in the class, gave the riskier defendant the higher score when you gave them the risk score, and the rest basically gave them the same. So even though it was a small sample, it was like a significant and large result. Now that's just students, it's just a tiny study, but I don't think that judges necessarily react that differently, like given that there's studies of how judges respond, for instance, to expert testimony on quantitative issues in other contexts that suggests that they're similarly informed by, or likely to defer to those kinds of assessments. So yeah, like I think it's an empirical question what it will do And I'm not sure that we shouldn't be also considering other alternatives.
Your response raises the question of how judges should understand the risk scores with which they're provided, or the risk classification. So, Richard, I'd like to put this question to you. When you have a risk assessment instrument in the pretrial phase or sentencing phase that produces a risk score and classifies someone as high risk, or a machine learned algorithm that classifies someone as high risk, what does that actually mean in a quantitative sense? How should judges understand that forecast?
It just tells you, it just provides an additional piece of information that's more explicit about some value of risk. And in my experience with loads of criminal justice decision makers, it's not a problem. They understand it. You can even tell them in quantitative terms how reliable that is. They understand that too. They're not stupid.
So if you were to tell them in quantitative terms, what would you tell them for your domestic violence forecasting, for instance?
In this particular case, we just provide a thumbs up or thumbs down and then a reliability count. So we say, this is someone predicted to beat this woman again, and we say the reliability is, let's say, 90, which is very high. We give them a scale. Oh yeah, well, they understand that. These aren't stupid people.
Okay, now correct me if I'm wrong, but if I understood your model and other similar models, for the people who are forecast to have that outcome, to be rearrested for another domestic violence, the statistical model classifies people in that group, and among the people who are classified as high risk, the forecast accuracy rate is something like 22%, right? Which is not...
Okay, now you're getting into a technical problem. We can go there if you wish.
Yes.
The policy position that's taken is that it's much more dangerous to release Darth Vader than to incarcerate Luke Skywalker.
Yes.
That is a policy call. The policymakers are very sophisticated about this. All sorts of different stakeholders understand it, including victims advocates groups who generally agree with the stakeholders. They'd much rather not have Darth Vader running around in their neighborhood. So, that is built into the forecast and leads to a choice to be much more accepting of weaker statistical evidence for Darth Vader, because we don't want to miss them, than we would accept for the Luke Skywalkers. That's a policy call.
And so just to clarify for the audience, this means that when a risk assessment instrument or algorithm is developed, the developers of the algorithm, whether it's the programmers or the stakeholders, as in Richard's case, he solicited this decision from the stakeholders, set a risk threshold at which they will classify someone as high risk or likely to have the outcome of concern. And that risk threshold is a statistical probability that a person will have the outcome of concern, whether it's rearrest or rearrest for a specific crime. Now, in Richard's case, the policy stakeholders thought that it would be much worse to accidentally release someone who then did have the outcome of concern than it would to detain someone who, in fact, would not have had that outcome had he been released. And so that led to setting the risk threshold around 20%, 22%, if I'm not mistaken.
Well, no, that isn't quite the way it was done. But yes, qualitatively, that's the good description.
Right. Now, one follow-up question to you. It is my understanding that that same decision must be made in the development of any risk instrument, including a checklist instrument.
Absolutely.
Can you explain how it happens?
Well, what happens is that they run these regressions, and Sonia's absolutely right. It's mysterious where those weights come from. When you try to reconstruct them by reverse engineering, you can't. But those risk scores are tallied up, and then they look at some data and see for different scores the proportion of individuals in the past who created problems. And they draw a line at some point. So if 70% of individuals with this score reoffend, that's high enough, bang, everybody over that score gets classified as high risk.
So final question on this point, and then we'll move on. Do any of you know, for the current risk assessment instruments in use, for people who are classified as high risk, what is the statistical likelihood of reoffense for that group?
It really depends on the application. In some of them, you're almost certain. In some of them, it's very unlikely. It depends on the kind of crime and the kind of individual. That's the point. There's variation in the risk, and the instruments that are used are differentially effective in predicting that risk But it's, again, I keep saying, it's much better than current practice. We will be releasing more people from prison and from jail if we use these, and our decisions will be better informed.
Thank you so much. Did you have anything to add to that,
The
Sonia?
only thing I want to add is I find it, I think it's very interesting that this is in Pennsylvania, policymakers that said that they want you to err on the side of locking up Darth Vader. Because some of the advocates of risk assessment, many of them, are actually pushing it as a tool for reducing incarceration, right? They're pushing it as like, this is how we're going to persuade judges to let low-risk people go. And I have always been, I mean, it could be used for that purpose, right? But I have always been skeptical about the idea that that is the sole purpose it's going to be used for, because if people have a policy preference essentially for erring on the side of caution with respect to crime, that's not the direction that's going to cut. And I think that we also can't really realistically expect judges, especially elected judges, to pay more attention to low risk assessments than they pay to high risk assessments. So, you know, whether it's better to err on one side or the other, I agree, it is a policy question, but I think that the sort of presumption of many advocates that like this is always a you know, incarceration reduction tool is something that we should not assume.
Quick follow-up from Richard.
Yeah, just a little bit of data. Here in Philadelphia, we have a system in place in the probation and parole department. And the idea was to forecast risks so that the parole and probation folks could better allocate their resources. When we did that, we found that about 60% of the people currently under supervision were virtually no risk, and they get virtually now no supervision. Going to your concern that we're going to over-supervise. Quite the opposite. What the budget requirements led to was a need to concentrate the services on those individuals most in need. So it was a more intelligent use of services. So we focused on the folks who we think need the most services, and the others got a terrific break. Budget constraints are going to force various agencies, jails, cops, prisons, whatever, to allocate the resources sensibly, and that's going to mean less interventions for people who we forecast to be low risk, and rather focusing those tools on people who we do think need it. So it's actually, there's data on this. These concerns are real, but so far they don't seem to be real in practice.
All right, last question maybe to the panel, and Zeke, if you could start us up, that'd be great. To my knowledge, the current measure of risk that most pretrial instruments use, and I know less about sentencing and other instruments, is rearrest, the likelihood of rearrest. Is that the right measure of risk? And if not, what is the right measure of risk?
Well, I don't think the likelihood of rearrest is an appropriate measure in many ways for the reasons that I talked about. Whether you are likely to be rearrested, I think, says much more in many cases about policy decisions, about where the police are going to go and where they're going to be determined to discover crime than about where crime is actually occurring. So you're really predicting, in a way, you're predicting policing more than you are predicting rearrest. I mean, who's actually committing crime. I mean, it is a challenge in terms of how do you, because as I said, I think the status quo where judges make their own subjective, often racially biased decisions and class biased decisions about who to let go, often driven by politics, hasn't been working. I think the jury is still out. I understand there's some evidence maybe to the contrary. Long term, whether risk assessment tools that are relying so heavily on really this kind of self-fulfilling prophecy of risk is going to, in the end, both result in long-term decarceration, when I think in many ways you're keeping people very much entrenched in the carceral state, and two, could lead, even if we do decarcerate, which I think is an important goal, to what is really to use an annoying term, I guess, carceral archipelago of surveillance. I was imagining the other day, what if we walked around, and this is being a little bit hyperbolic, but 80% of black men in certain communities are walking around with ankle monitors, right? And 2% of white men are walking around with ankle monitors, and the government knows where they are at all time. And it's not that far-fetched in that I was in Wilmington, Delaware recently, and 60 to 70% of black men, I think between the ages of 18 and 40 in Wilmington, Delaware, are on probation. They can't vote, they're monitored all the time, they're violated for the pettiest of things, and so that's not a world that we want to end up in, and I think risk assessment tools and using kind of what sounds like objective evidence to say this person in this community is very risky, just, it basically keeps us in the same place we are today. It's just a slightly different view of control and surveillance. So it's not, I don't have a great answer of what kind of things should judges take into account that would make it unbiased, because we live in such a deeply racially biased world, and racist in many respects, that, and this isn't a satisfying answer, whether we're using risk assessment tools, frankly, or judges, or humans' kind of implicit kind of instincts. I think we're not going to be in the world we want to be in. The other thing I just want to say quickly, which is a broader policy issue, there are other ways to lower jail populations, obviously, than releasing people to supervision and to probation. You have to look at who you're criminalizing, why you're arresting people in the first place, and obviously where you're investing your resources. Should it be in surveillance and supervision, or should it be in other areas of community engagement that long-term could have a much more dramatic effect?
Let's have a quick follow-up from Richard, and then we'll open it up to you all.
Yeah, this is actually a good transition to the comments from the audience. Here's what I maybe hyperbolically get out of this. No data are any good. The criminal justice system sucks, and all the actors in the criminal justice system are biased by race and gender. Now, if that's the takeaway message, we might as well just go home. There's nothing more to do. Turn it over to you.
Well, let's begin with a question from Professor Stefanos Beavis.
All right, thank you all. This is a great panel and kickoff, and I want to throw out something that I distill what I take to be one of the themes of this discussion that I hope will run through the coming ones, which is, in the abstract, data and numbers have the power to increase rationality, transparency, accountability, and thoughtfulness. And yet, I think you guys have hit on a number of things that happen when this gets thrown into the sausage factory that's the criminal justice system, right? We have salience bias, which is you're going to focus on the one person who reoffended after being released or cut a break. We have overestimation. We have risk aversion on the part of the judge and the prosecutor who don't want to be responsible for the one guy they let go who commits some other crime. And so there's the tension between the ideal of numbers improving rationality and the reality of numbers leading to, for instance, net widening. I think Richard touched on something in the question back and forth that was helpful. What are the mechanisms that can force us to do rationing, force us to do trade-offs, force us to stop saying more, more, more? I mean, dollars and budgets in the abstract help with that. But I am concerned that, you can define anybody. You let someone go who had a 5% chance of committing a violent crime. Don't you care? And so I just worry that the way the system is set up and the psychology of responsibility and risk aversion and salience and all really cut against the promise of rational use of numbers. And you also have the drunk in the lamppost problem, which is when you have numbers, they fixate people on, as Sonia pointed out, they fixate people on who is the big risk, even though without that fixation, we might think that other values matter more. So there's a distorting effect on judgment, and I'd like some thoughts about how we operationalize a more balanced and productive use of numbers in a way that seems, reflectively dispassionate and sensible.
I'd like to, if I may, jump in very quickly and then turn it over to you guys. One suggestion that I myself have, and I'd love to hear your thoughts on it, is that risk assessment instruments, when they classify a person as high risk, should clearly communicate to the decision maker what the statistical risk is of that person having what outcome. So a pretrial risk assessment instrument, it varies by instrument, as Richard was saying, but it might be the case that someone who's classified as high risk, that means on the basis of the validation studies for that instrument, there is a 13% chance that that person will be rearrested in a 4-month span. That is the information I think decision makers should have that would at least allow a rational conversation. comment on that?
Well, just quickly, so I think, for instance, in New Jersey, I think that information is going to be provided to judges. So you actually know not only is this person, what their score is and kind of where on the grid they fall, but what is their chance according to the, generalizing from the population that they will reoffend, which is why also, just to make the point, I do think, and this maybe doesn't get entirely to your question, but you have to have a system in place where this information is contextualized by kind of human facts as well as data. And so if you had a defense lawyer who's well trained in these things, you just said 15% chance, right, of reoffending. The lawyer may reframe that, right? There's like my client, there's an 85% chance or a 92% chance, right, that he is going to be back in court and not reoffend, and then describe why. And so I think you're going to have the data, but we have to humanize it in part. And I think judges are also going to have not only the scores, but in theory they need to be given here, and there are risks to this, but here are the kind of appropriate, with release being the presumption, here are the appropriate conditions that we would assign. And in Kentucky, for instance, where I don't think they were doing that, where they went through a lot of pretrial justice reform, there were some judges who were following the risk assessment tool and incorporating, and some who were just flatly rejecting it and sticking to old practices. So I think judicial education with the presumption of release and robust defense counsel advocacy would help to avoid some of these pitfalls.
Richard or Sonia, did you have something to add to that? Or should we take another question?
I guess I would just say, so briefly on Sandy's suggestion that if you were going to do that, I think it would be important also to develop risk assessment instruments, which many of the existing ones don't do, that differentiate by what the person is going to do, right? Because the truth is that, many of the existing instruments don't do that. It's just, do you get rearrested for anything? As a result, for instance, drug offenders tend to have higher risk scores than violent offenders. And that's because drug offenders are much more likely to get rearrested, but who cares? They're getting rearrested for drug possession. It's not a big deal. And so that's just another problem. I think that Stefanos' question, though, is sort of a broader, how do we get people to value things differently in the criminal justice system? I guess the only answer, I don't really know that risk assessment technology provides an answer or particularly worsens, or it might worsen it. I don't know. I think the answer is it's politics, right? It's getting people to, it's social movements. It's getting people to recognize that there are harms to over-incarceration. And I think that's something that actually, not only the fiscal conservative movement in recent years that has focused on the cost of incarceration, but also the Black Lives Matter movement, the libertarian, the rise of a libertarian movement on the right. There are actually veins of political change on this issue that are happening, such that when Bill Stuntz wrote 20 years ago that we have this politics of ever ratcheting up harshness in the criminal justice system, this will never change, the political incentives are all aligned in one direction. I think that's changing now, finally, maybe because the system has hit a breaking point. And so I'm a little more hopeful. I actually don't think everyone in the criminal justice system is evil, or that there's no hope for change.
Next question.
I was a judge for 17 years. My name is Nancy Gertner. I have a number of things to say, which I will say very quickly. First, part of the search for numbers here was that we were laboring under a guideline system which was based on error. That is to say, the sentencing guidelines and the measures that they were using, which was for the purposes of rationalizing sentencing, those measures were themselves based on nothing. And so to some degree, I understand the enormous desire to have at least a structure that is based on something. I take Sonia's point that the something here is flawed. And it's flawed not only for the reason some of you intimated, but also it's flawed because it doesn't take into account what good correctional intervention might do. So you anticipate risk assessment without looking at the programs that might very well make a difference, or the mental health programs that might very well make a difference. In addition, this is to Stefanos' point, you have to sort of juxtapose any sentencing, and that's just what I know most, any sentencing approach in the context in which it will be done. So you put it in the Pennsylvania or the Boston or the Massachusetts courts where they're processing thousands of people a day, and it will not be done contextualized and in an interesting way. It will be done formulaically. So that if there are problems here, the problems then get really exacerbated. So I almost want to map this interesting scientific discussion on top of cognitive theory, which is, of course, we'll reach for numbers. Of course, you'll reach for the formula. The sentencing guidelines have become advisory. They're followed 80% of the time, even though they're absurd. So that's something to be concerned about. And in addition, I very much take Sonia's point that you want to unpack what these issues are, what the correlations are, because if you don't unpack them, we won't be addressing the real causes of crime. So, for example, when you look at socioeconomic factors, it really maps onto what neuroscience talks about as the impact of toxic stress and the impact of social background, abuse, malnutrition, etc. In a risk assessment universe, we'll say, oh, well, that leads to the likelihood of reoffending. In a policy world, you'd say, gee, what are we going to do about that? What are we going to do about that in general? What should we do about that in particular? So there's a risk that the discussion takes your eye off the ball of what is meaningful intervention on the one hand and meaningful structural change on the other.
Thank you so much for those comments, Judge Gardner, and for being here today. As a follow-up question to the judge's comments, I'm curious, Richard, whether you think the development of machine learning algorithms, given their black box nature, can we nonetheless use them to help us identify risk factors that, for policy purposes, we might want to unpack and address through other kinds of interventions?
Well, the problem is that these techniques are not models, so you have no explanation. But the problem is even the models are not really models either. So there's this ideal world that if we look at correlations, we'll understand. That's a little silly, a little naive. And the reason is that race and gender and SES, as everybody has already alluded to, is related to everything. You cannot disentangle it. Can't be done. So the real question is what level of imprecision or bias are you prepared to live with? It's never going to be clean and perfect because everything is related to everything. I think the idea that you can somehow run correlations and learn something that's going to be persuasive is just not going to work. Well, we have 50 years of history. It doesn't work.
Okay. On that bleak view, we'll take one...
I just wanted to the extent, as Richard categorized my earlier comment, I was suggesting that everyone in the criminal justice system, judges and prosecutors, police, defense lawyers, are, profoundly racist people. That would include myself. I guess that was not the point I was making. I think you actually just got at the point I was trying to make, which is maybe more succinctly that the idea, which is I think peddled by some, not apparently by Richard, is that somehow using risk assessment tools will make this process objective and take race out of the equation and eliminate racial bias in terms of predicting who's going to commit future crime. And I think that would not happen. And so I don't think this would be moving us into a post-racial criminal justice world. It was really my point.
Great. We're going to go till 10:10 because we started a few minutes late. We'll have two more questions, the two gentlemen standing up here, and then wind up. So we'll begin on the right.
Long-time public defender in Philadelphia. And much like Zeke, I'm sort of a stranger in a strange land in a conference dealing with statistics. But in the last few years, we in the criminal defense bar have been thrust into this world of statistics by things like risk assessment tools. So my question is, a lot of these tools deal with age at first arrest. A lot of these tools deal with criminal history with talk about, which include arrests. And then at least some of these tools deal with the ultimate prediction or the risk assessment is of arrests. So you have arrests begetting arrests, becoming arrests, predictions. And if you look at this closely and sort of go through the weeds, it would seem like a lot of this is generated by the police. I mean, they're doing the arresting based on race, based on neighborhoods, based on this, based on that, based on a lot of things that we see every day in criminal courtrooms. So, does anybody want to comment on that? Arrest versus arrest upon arrest equals arrest.
Yeah, it's not true. That these risk assessments take into account things like age, and we know that the relationship between earlier arrests and later arrests declines rapidly, at least for street crimes, after 25. We have other information as well, so it's not a lockstep, but I think it is also true that if you look at arrest patterns, particularly crimes that have been committed shortly before the instant crime, they are predictive. Now, if it turns out that this is because police are arresting all kinds of people that shouldn't be arrested, we have a really serious problem. But I think we'll agree it's a matter of degree. And if you want to throw out all arrest data, you can throw out all other data, including the data that judges use routinely, and then we are, as someone said, flying blind.
All right. With apologies, that's a longer conversation we could have, but let's take the last question and then wind up, and hopefully the panelists will be here to speak to people after the panel.
My name is David Lair. I'm affiliated with the Penn Program on Regulation here. My question goes primarily to Sonia, but I'd love to get all of your comments on this as well. When you were discussing the constitutionality of including certain variables in these risk assessments, what was particularly problematic about them was that they treated individuals as groups based on these statistical generalizations about groups. The predictions weren't individualized. And I'm wondering how transferable you think that criticism might be to risk assessment paradigms based on machine learning, where it might be argued that you do have this kind of individualized risk assessment being done, where membership in a given class, say, might have different and opposing effects on the ultimate predicted risk in concert with interactions with many other variables in that assessment paradigm as well.
Well, I think the problem is that all of the predictions are still being made on the basis of what a bunch of other people besides you did in the past, right? When you say that it's more individualized, you just mean there's more different groups that you belong to, or more different interactions of the different kinds of groups that you belong to that are effectively being taken into account, right? It doesn't mean that you are being assessed for yourself and that the assumption is that you might differ from the characteristics of people who share your characteristics. Again, this is a really a legal concern. It's not a scientific one. Like on average, these things provide good predictions for groups. But the point is, it's sort of like in the VMI case, for instance. There was good empirical research that says that it was much more likely that a higher percentage, although still a low percentage, but a higher percentage of men than women are likely to thrive in the highly confrontational environment of military education, right? The court says, okay, so not very many women are really going to want to go to VMI, but not many isn't zero, right? Like, there are women that diverge from the average, and we should allow for that in our constitutional law. Now, of course, the state has to generalize, right? It generalizes about different kinds of characteristics all of the time, but the point of making certain classifications demand elevated scrutiny because we think that they're morally problematic is to say that generalization, that we don't allow the same type of generalization on the basis of those characteristics that we do on the basis of others.
All right, thank you.
Just on the public defender point, I just have to reiterate that, I mean, the police are indeed stopping and searching and arresting people that they shouldn't be, and they're also doing it selectively, and the data does kind of show that. So I think that's a big concern for using arrest data for predictive purposes.
Let's continue this conversation today and tomorrow over the course of the symposium. Please give the panelists a round of applause.